What about now? What about now? Can you hear the audio now? Testing, testing, auditor, testing. What about now? What about now? Can you hear the audio now? Oh, yeah, okay, beautiful. Hey, how's it going, guys? Damon, Hot Rod. Testing, testing, auditor, testing. Loud and clear, beautiful. All right, guys, we're going over Supreme Court rules. This will be for the state of Illinois, but it should be relatively the same nationwide. If we take a look here, this is actually part two. We left off at the 300 range. This was a year ago. I had did the first part from 0 to 300. So we looked at the rules from 1 to 300, and we're going to go ahead and do part 2 right now, which is 300 and on. The Illinois Supreme Court rules, I believe they come in 5 parts. Nevertheless, your sound is kicking on and off. Fake mic? I don't see fake mic. Sound is Alrighty, anyhow, let's get right to it. We're just looking at titles. If there's something unique or something of interest, we may click on and read through. Rule 302 is direct appeals to the Supreme Court. 303, appeals from final judgment. Appeals from final judgment. Well, appeal from final judgment, 30 days, I believe. Hey, Fake Michael, how's it going? Rule 305, stay of judgments pending appeal. Oh, wow. 306, interlocutory appeals by permission. Hey, Eyes on the Audit, how's it going? 307, interlocutory appeals as of right. 308, certified questions. Dismissal of appeals by trial court, 309. 310, pre-hearing conference in the appellate court. 310.1, appellate settlement conference program. 311, accelerated docket. 312, docketing statement. 313, fees in the reviewing court. 315, leave to appeal for the appellate court to Supreme Court. 316, appeal from the appellate court to Supreme Court on certificate. 317, appeals from the appellate court to the Supreme Court as of right. 318, general rules governing all appeals from the appellate court to the Supreme Court. 321, contracts of the record of appeal. Yeah, this is all in the appellate section here, these rules. Report of proceedings, 323, 324, preparation and certification of the circuit court record on appeal. 325, transmission of record of appeal or certificate in lieu of record. Time for filing record of appeal is 326, 327, notice of filing record, 328, supporting record, 329, supplemental record on appeal. Time for filing record. Rule 330, captions in reviewing courts. 331, return of the record on appeal. 332, reserved. 335, direct review of the administrative order by appellate court. What is the signal going in and out? Rule 341, briefs. 342 is the appendix to the brief. 343 is the time for filing and serving the brief. Sound drops out. 345, brief amicus. 351, sequence and matter of calling cases for oral argument. 352, conduct of oral arguments. Rule 361, motions in reviewing court. 362, amendment of pleadings and process in the reviewing courts. 363, inspection of original exhibits on appeal. 364, privacy protection for documents filed in courts of review. 365, appeal to wrong court. 366, powers of reviewing court, scope, review, and procedure, lien of judgment. 367, rehearing in reviewing court. 368, issuance, stay, and recall of mandates from reviewing court. 369, filing of mandate in circuit court and proceedings thereafter. 370, process in reviewing court. 371, confidential records when on review. 372, removing records from reviewing court. 373, date of filing papers in reviewing court, certificate of mailing. 374, costs in reviewing court. 375, failure to comply with rules, frivolous appeals, sanctions. How about the rules of evidence? What number is that? Did we just go over? 381, rule original action in the Supreme Court pursuant to Article 5, Section 4A of the Constitution. This is not legal advice. Don't try this at home. 382, original action in Supreme Court. Yeah, okay, so 383 is motion for supervisory orders. 384, proceedings for the transfer and consideration of multi-circuit actions. Oh, wow, multi-circuit actions. Consolidation, proceedings for transfer. So you know what, let me write down some of these on the paper, on a memo pad, so we could review and open them up. Here, let me write it on this right here. Alrighty, so we're going to go ahead and put 384. Alright, carry on. 401, waiver of counsel. That to be looked into. Okay, 402, pleas of guilty or stipulations of sufficient to convict. Pleas for guilty or stipulations for sufficient. That's another one right there. Okay. 402A, admissions or stipulations in proceedings to revoke probation, conditional discharge or supervisions. So in the 300 range, I think we were in packet 2, which is the appeals. I think now in the 400 range, we're getting into the criminal side. Pleas and waivers by persons under 18. 404, error. Application for a waiver of court assessments. Application for a waiver of court assessments. Rule 411, applicability to discovery rules. Oh yeah, there's 2 I think of those discoveries. We're gonna write that one down. Okay. Disclosure to accused, that's at 412. 413, disclosure to prosecution. At 414, evidence depositions. 415, regulation of discovery. DNA evidence at 417. 430, trial of incarcerated defendant. 431, void your examination. 432, opening statements. Yeah, there's a rule for opening statements. That's pretty cool. So we're gonna go ahead and write that down. 432. 433, impeachment of witness, hostile witness. 434 is at jury selection. We have 436, separation and what's that? Sequestration of jury criminal cases. Admonition by court. We are at instructions, rule 451. 452, preparation of sentencing orders. 455, filing of hearing and trial exhibits. Filing of hearing and trial exhibits. And at 471 is transcripts for poor persons bringing post-conviction proceedings. At 472 we have correction of certain errors in sentencing. At 501 we have definitions. So here we're jumping into a new packet here, I believe. And if we go to 504, that's appearance date. 505 is notice to accused. All these reserved. 529, written pleas for guilty in minor traffic offenses. 530, written pleas for guilty in conservation offenses. 531, written plea of guilty in overweight and permit offenses. It's probably trucking. 551, traffic and conservation offenses for which a court appearance is required. Uniform tickets processing. Oh, that's a cool one. 552. Look at that one. Check your state Supreme Court rule for uniform tickets processing. 555 is the requirements for a written plea of guilty. Rule 556 is procedures in the defendant if a defendant fails to appear. 557, preparation of sentencing orders. 558, correction of certain errors in sentencing. 570, applicability. 571, code of civil procedures to apply. 572, forms of charging document. Form of charging document. Here's another one, 572. 572. Service of charging document. So we have form and we have service at 573. 574, opportunity to settle. 574. 575, appearance to defendant, answer, failure to appear, discovery, and pretrial proceedings. 576, right to counsel. 577, jury trial. 578, burden of proof. 578. 579, disposition of and appeal. 585. 586, appearance date. Okay, yeah, this is all. Failure to appear. Okay. Let's see the 607, appeals by indigent person. Record of appeal. 609, stays. 609, stay, to hold. 611, oral argument. 612, number of copies to be filed, procedural matters which are governed by civil appeals rules. 613, mandate of reviewing court. 614, notifying prisoner of affirmative affirmance by appellate court. Hey, your appeal has been the 615 is the cause on appeal. Appeals and post judge conviction proceedings. Okay. Yeah, this is most on the criminal side. 7, alright, here we are getting in the 700 range. 700 range. Board of Admissions to the Bar. Board of Admissions to the Bar is at 702. Educational requirements, 703. 704, qualification on examination. 704A, admission by transferred uniform bar examination score. 705, admission on motion. 706, filing deadlines and fees of register and applicants. 707, permission for out-of-state attorney to provide legal service in proceedings in Illinois. 708, Committee on Character and Fitness. This is all attorney stuff. 709, power to make rules, conduct investigations, and subpoena witnesses. 710, immunity. Oh, we gotta check that out. 710. 711, representation by supervised law students or graduates. 712, licensing and foreign legal consultants without examination. 713, applications for licensing of foreign legal consults. 715, admission of graduates of foreign law schools. 716, limited admission of house counsel. 717, limited admission of legal services program lawyers. 718, provisions of legal services following determination of major disaster amended. Alrighty. 719, admissions of military spouse attorneys from other jurisdictions. 721, professional service corporations, professional associations, limited liability companies, and registered LLP for the practice of law. LLP, limited liability partnership firm. Well, let's take a quick look at that one again. Yeah, you know what? Let's mark that down. 721. All right, go ahead and carry on. 722. Limited liability legal practice. LLLP. 7:30 Group Legal Services. 7:51 Attorney Registration and Disciplinary Commission. Administrator 7:52. 7:53 Inquiry Hearing and Review Board. Inquiry. Subpoena power at 7:54. 7:54. Assistance of members of the bar. Rule-making power of board. 7:57 Transfer to disability and active status upon involuntary commitment or upon judicial determination of legal disability because of mental condition. 7:58 Mental disability or addiction to drugs or intoxicants. 7:59 Restoration of active status. 7:60 Appointment of medical benefits experts. Conviction of crime. 7:61. Let's mark that one down. 7:61. 7:62 Disbarment and other discipline on consent. Oh, that's scary. Either disbarment, you're done, or disciplinary action at 7:62. 7:63 Reciprocal disciplinary action. 7:64 Duties of disciplined attorney and attorneys affiliated with disciplined attorney. 7:66 Confidentiality and privacy. 7:67 Reinstatement. 7:68 Notification of disciplinary action. 7:68. Yeah, these might be cooking. 7:68. Maintenance of records at 7:69. Types of discipline. 7:70. Finality of orders and effective date of discipline. Probation. 7:72. 7:73 Costs. 7:74 Interim suspension. Immunity. 7:75. 7:76 Appointment of receiver in certain cases. 7:77 Registration of disciplinary proceedings relating to foreign legal consultants. 779 Unauthorized practice of law proceedings. 779 Client Protection Program is at 780. 790 Title and Purpose. 791 Person subject to MCLE requirements. 792 MCLE Board. 793 Requirement for newly admitted attorneys. 794 Continuing legal education requirement. 795 Accreditation standards and hours. 796 Enforcement of MCLE requirements. 797 Confidential. 799 Supreme Court Commission on Professionalism. Oh wow. Supreme Court order. Alright. These are subcategories, I think. Competence. Scope of representation and allocation of authority between client and lawyer. Scope of representation and allocation of authority between client and lawyer. Oh, wow. Let me just flicker on that. Rule 1.2, Scope of representation and allocation of authority between client and lawyer. A. Subject to paragraph C and D, a lawyer shall abide by client's decisions concerning the objectives of representation and, required by Rule 1.4, shall consult with the client as to the means by which they are to be pursued. A lawyer may take such action on behalf of the client as authorized to carry out the representation. A lawyer shall abide by a client's decision whether to settle a matter. In criminal case, the lawyer shall abide by the client's decision after consultation with the lawyer as to plea to be entered, whether to waive jury trial, and whether the client will testify. A lawyer's representation of a client, including representation by appointment, does not constitute an endorsement of the client's political, economic, social, or moral views or activities. A lawyer may limit the scope of the representation if the limitation is reasonable under the circumstance that the client gives informed consent. A lawyer shall not counsel a client to engage or assist a client in conduct that lawyer knows is criminal or fraudulent. Okay, yeah, we're gonna go through these at a later time. We'll look up evidence. Confidentiality of information, conflict of interest, duties to former clients. Alright, we're almost at the 800 range. Special conflicts of interest and former and current governmental officers and employees. Alrighty. Let's just check something out here. Alright, yeah, we'll leave at 3.3. Let me pull up now. There's a request for evidence. Let me go to evidence. Illinois Supreme Court rule, evidence. Yeah, that's 401. We did pass that up. Oh, wait a minute. It's saying waiver of counsel. Wait a minute. Rule 901? Authentication. Rule 901, authentication. No, that ain't it. Rules of Evidence, Illinois Supreme Court. Ruling on Evidence 103. 103. What the hell? This is all mixed up. Hold on a minute. My mobile phone has a totally different number. 102 purpose. Okay, here I got ruling on evidence at rule number 103 on my mobile device. But I could pull that one up. Let me pull that one up here. Rule 103 evidence. Give me a minute here. Rule 103 evidence. Alrighty, we're putting that bad boy up. (103). Here we go. Ruling on evidence. Alright. So I guess we'll review this one. We had a request for this, and we'll go ahead and continue that quarter review that's left, probably at a later time. The rules of evidence here at 103. Rule of evidence, effect and erroneous ruling. Error may not be predicted upon a ruling which admits or excludes evidence unless a substantial right of the party is affected. That's what I'm looking at. This is rulings of evidence. We're looking for rules of evidence. Isn't there a distinction? Error may not be predicted upon a ruling which admits or excludes evidence unless substantial right of a party is affected. And 1. Objection. In the case ruling is one admitted evidence, a timely objection or motion to strike appears of the record, stating that the specific ground for the objection. If the specific ground was not apparent from the context or offer of proof, in the case ruling is one excluding evidence, the substance of this evidence was made known to the party of the court or by officer, or was apparent from the context within which questions were asked. Preserving a claim of error for appeal. Oh, wow. Number 1, civil and criminal cases. In civil and criminal trials where the court has not made a previous ruling on the record concerning the admission of evidence, a I forgot how to pronounce that. Trial, objection, or offer of proofs must be made to preserve a claim of error for appeal. Yeah. Criminal cases. In criminal trial, once for the court rules before of the trial on the court record, on the record concerning the admissions of evidence, a contemporary, I forgot how to pronounce it, trial objection of the offer of proof not to be renewed to preserve a claim for error for appeal. Civil cases. In civil trials, even if the court rules before or at trial on the record concerning the admissions of evidence, a contempore, let's just say, trial objection or offer of proof must be made to preserve claim of error for appeal. Yeah, this is definitely, I'm going to have to reread this on my own at a later time. This is another good one. Post-trial motions. In all criminal trials and in civil juries, in addition to the requirements provided above, a claim of error must be made in a post-trial motion to preserve the claim for appeal. Such a motion is not required in a civil non-jury trial. C. Record of offer and ruling. The court may add any other or further statement which shows the character of evidence, the form in which was offered, the objection made, and the ruling therein. It may direct the making of an offer in question and answer form. D. Hearing of jury. In jury cases, proceedings shall be conducted to the extent practical so as to prevent inadmissible evidence from being suggested to the jury by any means, such as making statements or offers of proof or asking questions in the hearing of the jury. E. Plain error. Nothing in this rule precludes taking notice of plain errors affecting substantial rights, although they are not brought to the attention of the court. Yeah, that's a good one. Alrighty, anyway, just did a quick reading here. Part 2 of the Supreme Court rules. Now, if we did want to go back to '0 through 300, that's the one we reviewed last time, you would find it on my channel. There's a lot of good rules, a lot of things to be informed about in this entire Supreme Court rules for your state. So make sure you do look up the one in your state. Be informed. That's the best way to do it. Education is the key to success. Hopefully everybody reviewed, hit the thumb up, and if you have not, make sure you do. And if you're new coming into this feed now, make sure you go ahead and watch it from the beginning. Thank you guys again for tuning in. Audit Dim.